Video, we are going to discuss about the constitutional validity of capital punishment in India. Capital punishment or death penalty is awarded to the offender who commits capital offences like rape, murder, dacoity, accompanied with murder, waging war against government, or any of the offences according to the law where the punishment is given as death penalty. The Human Rights Commission considers death penalty as immoral, but the capital punishment awarded to the offenders to ensure and create a different perspective on the society. The provision of capital punishment or death penalty can be found under many statutes like Indian Penal Code, Indian Air Force Act, NDPS Act, Army Act, Navy Act, etc. Time to time, the concept of capital punishment is challenged into the court on the ground of that it violates the Article 14, 19 and Article 21 of the Constitution of India, which provides the protection of life and liberty, and which are the important fundamental rights to a people of India. The 35th Law Commission report in 1967 recommended to retain the death penalty. But in the year 2015, the Law Commission report number 262 recommended that the capital punishment should be abolished for all the crimes except the crime related to terrorism and waging the war against government. For the first time in India, the constitutional validity of capital punishment was challenged in the case of Jagmohan Singh versus State of Uttar Pradesh. In that case, the section 302 of the Indian Penal Code was challenged before the court that it was violated the Article 14, Article 19 and Article 21. That's why it was unconstitutional. But the 7 judges bench of Supreme Court, after rejecting all the arguments of the petitioner and held that the provision of capital punishment was constitutionally valid. The court further held that the law could not deprive a citizen's life unless it was reasonable and in the public interest. Later in 1979, again the constitutional validity of capital punishment was questioned in the case of Rajendra Prasad versus State of Uttar Pradesh. The Supreme Court again declares capital punishment as constitutionally valid and held that the death sentence should be imposed only if otherwise public interest or special reasons necessary for imposing death penalty. The extreme penalty can be invoked only in extreme situation. Most of the time, the court, while deciding a matter of capital punishment, the court follows the doctrine of rarest of rare case. The doctrine of rarest of rare is not found in any statutes or any book. It was determined after analyzing the sensitivity or gravity of the crime. In India, first time the doctrine of rarest of rare was introduced in the case of Bachchan Singh versus State of Punjab. The court in the case of Bachchan Singh versus State of Punjab held that a real and abiding concern for the dignity of human life postulates resistance to taking our life through law instrumentality that ought not to be done save in the rarest of rare cases when the alternative option is unquestionably foreclosed. The punishment of death or capital punishment validity was decided in many cases from time to time in many years. It clearly observed that the death penalty does not violate the fundamental right to life given under Article 21 of the Constitution of India. The court observed many times that to avoid death penalty, they must look into the convicts or the accused or the offender's main rea in the crime. And in some circumstances, or the most of the circumstances, the doctrine of rarest of rare should be considered. But the law does not define what will comes under the doctrine of rarest of rare or what should be comes under the category of rarest of rare. The death penalty is valid constitutionally because imposing a strict punishment will show the power of law, and in future no one would dare to repeat any types of rigid crimes in India. And India should not abolish or repeal the capital punishment. It will kill fear from the mind of the offenders. Thank you so much.